Welcome, everyone. This is Maggie Humphrey of the Toledo Bar Association. We have been working with the Center for Nonprofit Resources to find ways to connect our attorneys to local nonprofits, whether it be through speaking engagements or providing pro bono legal services to nonprofits who are unable to afford an attorney. Today, we are delighted to be partnering with the Center to pilot webinars. The topic of today's webinar is Common Legal Issues Nonprofit Boards Experience. I'm here with Heather Bradley, the director of the center. Heather will be monitoring any questions you may have throughout the webinar. Please type your questions in the Q&A section, not the chat box. We have time scheduled for the speaker to take questions towards the end of the webinar. Microphones are muted for participants throughout the presentation. A copy of the slides will be sent to you after the webinar. The last slide includes resources available through the center. This webinar is being recorded, and a replay link will be emailed to you within 24 to 48 hours. You will also receive a link to a very short survey to provide feedback about this experience. Testing the webinar format is a great example of the center acting on feedback from previous events offered by the center. Now it is my pleasure to introduce our guest speaker for today's webinar, Craig Burns from the law firm of Marshall Malhorn. Craig is a member of the firm's business section and has been helping nonprofit organizations resolve the many legal issues they face for nearly 30 years. He has served on a number of nonprofit boards over the years. He earned his bachelor's degree at Miami University, his law degree at the University of Virginia, and an MBA from the University of Toledo. Thank you for joining us, Craig. I will turn it over to you.
Thank you, Maggie. If you see the screen and you've been listening, it won't be any surprise what we're going to be talking about today, common legal issues that nonprofit boards experience. And if you've ever heard lawyers speak before, we always start with a disclaimer. How do we, my go forward button is not working here. Okay, so we always start with a disclaimer. So this is generalized advice that superficially covers a wide range of topics. It is necessarily oversimplified. In actual situations, facts and circumstances can change the result. So don't try all of this at home. If an issue comes up, make sure you consult with competent legal counsel, because the general things we discussed today here may not apply to your specific situation. So we're going to start by talking about board and officer roles and how those can sometimes come into play. So what is the board's role? Nonprofit corporations sometimes have members and sometimes do not. If you're not certain, you can check the governing documents, the Articles of Incorporation and Code of Regulations, and those need to state whether they're members or not. I assume most of the audience is involved with a charity. Charities typically don't have members, but some do. A few charities have multiple individual members. It's more common for a charity to have a single member. Often that single member is another charity. That happens in the healthcare context, some other contexts as well. So a nonprofit corporation with membership, the members elect the board. If there's an institutional member, typically that institutional member just appoints the board and has veto power over the board's actions, but the board carries on the business of the organization. If there are no members, you have what we call a self-perpetuating board. So typically the board elects itself, and the directors have the power of members. That's a citation to the Ohio Revised Code, where it says the directors, if there are no members, the directors exercise that power. Sometimes you'll see documents that say the directors are the members. I don't like that, because members and directors have different roles and different ways of voting and things. So I like to say the directors have the power of members, but do not say that the directors are members. Now the citation here is to the Ohio Revised Code. But the citations I'll be giving you are generally to that. I assume most of our audience will be in Ohio. A lot of these principles will apply nationwide in other states as well, but we'll focus on Ohio for our audience. So ultimately, who's the ultimate authority for a nonprofit organization? Where does the buck stop? If it has a membership, it is probably with the membership. The membership is a body. If there's no membership, then the ultimate authority is the board. Again, the board acting as a body. So the roles of directors and officers, sometimes you'll hear directors called board members or trustees. Years ago, the nonprofit statute referred to trustees rather than directors. A for-profit corporation had directors, a nonprofit had a board of trustees. The Ohio statute and most other state statutes now refer to directors, and that's a good change because the trustees are, the duties of a trustee are defined in other law involving a trust, and a trustee is not quite the same as a director. There's some similarities, but it's different. And I really don't like the term board members because member means something else, as we just saw. The members are different than the board. So I like to talk about directors instead. So the directors make up a deliberative body. They're kind of the legislative branch. If you think of the corporation as having a government like ours, the directors are the legislative branch, and the officers are kind of the executive branch. The officers are the ones who carry out policy. The directors, as a body, set policy. The officers carry out the policy. So, is there a judicial branch? Our U.S. government has 3 branches. There's not an internal judicial branch for a nonprofit organization, but there are other organizations that can resolve disputes. I mean, obviously, if there's a dispute over a nonprofit corporation, a court might be invoked, and in some cases, the Internal Revenue Service and the Ohio Attorney General have jurisdiction. So how are directors and officers different? As I said, directors act as a body. Officers act individually. A director can't sign as a director, can't sign a contract as a director because the director has no authority as an individual director. But the same individual can be an officer and a director, and that's usual practice in a nonprofit. Usually the officers are also directors and they're volunteers. So if you're both an officer and a director, you sign a contract, you would sign as president, for example. You wouldn't sign as a director. The best practice for charities, again, not all nonprofits are charities, but for nonprofits that are charities, the best practice is that all of the directors are unpaid, all of the officers are unpaid, and all officers are directors. It's not necessarily true that all directors are officers. You can have directors who are not officers, but typically all of the officers are directors. I put an asterisk about all officers being unpaid because we're going to talk a little bit later about executive directors. So what officers are required? Under Ohio law, you have to have a president, a secretary, and a treasurer. Other officers are optional. You can have one or more vice presidents. You can have, I guess, an assistant secretary. I guess you could have more than one. Assistant treasurer. Sometimes you see an office where they call someone a board chair, a chairman, or a chairperson. Nobody's really figured out, or there's not a consensus on how to make that term gender neutral. Board chair sounds like an item of furniture, so but it avoids the issue of gender, I suppose. What is that role? You can set a role for that in the Code of Regulations, but I'm not sure that some organizations have that, some don't. You don't necessarily need to have a board chair. I mean, if you don't have a separate board chair, then typically the president acts and presides over board meetings. So the president kind of has that role unless you give that role to someone else. Some organizations have a president-elect. The Toledo Bar Association, for example, elects a number of presidents-elect, and then each year they rotate up a slot. So the first president-elect becomes president, and that's a way of ensuring continuity. So that's, but there can be other officers. I once had an organization that wanted to have 3 presidents. That was a strange situation. I couldn't tell them that I couldn't find authority that they definitely could, but I couldn't find anything saying they couldn't. But that was an unusual situation. So how many directors are required? For many, many years, Ohio law required nonprofits to have at least 3 directors. There's no maximum limit. You need at least 3. Recently, there was a change. So if you have members and there's only 1 member, you can have 1 director. If you have only 2 members, you can have 2 directors. If you have no members, then the three minimum applies. So the number of directors is typically established in the Code of Regulations. There's usually a fixed number or a range. It might say at least 3, but no more than 12, for example. In directors, if there's nothing different in the Code of Regulations, they serve for 1-year terms, and there are no term limits. A lot of nonprofits, though, will have staggered terms. They may, for example, elect a director for a 3-year term, and then they try to elect directors about 1/3 of the board every year. So that, again, they have continuity and they don't have a complete line change. It's not like going to see the walleye where everybody comes off the ice at the same time and the new line comes back on. So what is the best size? That depends in part on the organization. The board should be big enough to have a diversity of views, experience, and skills on the board, but not so big as it's unwieldy. If you have a board, I mean, there are a few nonprofits around that have boards of more than 20 members. Sometimes just getting a quorum can be difficult. And if you have too many directors, they risk becoming perhaps not as involved as they should be. If you have a large board, one way of dealing with that issue, sometimes or often there's an executive committee that can be a subset of the board. Often the officers make up the executive committee, but it doesn't have to be that. And I know some organizations where the board only meets, say, every 3 months, and in between the executive committee has authority to make decisions, and then at the next director meeting, the board can ratify or nullify what the executive committee did. Another way of dealing with the board issue is to have an advisory committee. I've heard this called a president's council, where the actual board that has fiduciary duties is relatively small, but then you have a larger organization or a council that does not have fiduciary duties, that helps with fundraising and perhaps representing community values, community opinions. I like that idea because if you have 25 people and all of them have fiduciary duties, which we're going to talk about in a minute, and not all of them are participating, it's kind of risky. So all things being equal, I'd prefer smaller boards to larger boards. Can staff be officers? By staff, I'm talking about anybody who's on your payroll. And the question here is, I guess there are 2 questions. Can staff be officers? Should staff be officers? So yes, staff can be officers. You can have a paid employee who is an officer. You can perhaps have a paid employee who's a director as well, but that's not considered best practice. It's considered best practice to have all of your directors and officers be volunteers, and to have all of your staff, everybody who's on the payroll, not be a director or officer. It helps with conflicts of interest. It helps with combating undue influence of the staff over the organization, and making sure that the people governing the organization have no conflicts, no incentives to act other than in the best interest of the organization. Executive director, in most organizations, there is someone who is kind of the equivalent of the CEO. I've seen them called the CEO. Often they're called an executive director. That's sort of the chief staff person. And it's kind of a hybrid role, because in some ways they're acting in a role that's similar to an officer. They're implementing policy, they're making hiring and firing decisions. But it's best if that person is not an actual officer, statutory officer. Not a president, secretary, treasurer. So it's a hybrid role. It works out best, I think, if you have a volunteer president who works closely with the executive director. So you have the president representing the board and who's not on staff, who's working closely with the executive director who is staff and who is on the payroll. Finally, it would be very dangerous for the executive director to be an independent contractor. I know of one organization where the executive director insisted on being an independent contractor. The board went along with it. They didn't know any better. Later on, it turned out that the executive director didn't file taxes, didn't send, didn't have the organization send him or her a 1099, didn't pay the taxes, income tax or self-employment tax, and the organization and the individual directors were personally liable for the taxes that didn't get paid. That was a disaster. And just as a practical matter, the executive director probably really should be an employee. The IRS has a 20-factor test over whether someone is an employee or an independent contractor. The executive director, in most cases, really should be an employee. So what about the CFO or the controller? Some organizations want to make the staff member who handles the financials the treasurer. I think it's better to have a volunteer treasurer and to have the CFO or controller, the person who's your employee or perhaps paid outside staff, work with the volunteer treasurer. So again, you have somebody who's a volunteer representing the board working with somebody who's an employee. Next, we'll talk very briefly about changing the governing documents. The governing documents are the Articles of Incorporation and the Code of Regulations. So how do you do this? If your organization has members, the members need to approve the changes. The asterisks here mean you have to read the governing documents. I'm going to tell you what the statute says, but the governing documents can change this. If there are members, you need to have the members approve, and the majority of members present at a meeting can make the change. And unless your document says otherwise, whoever shows up to a duly convened member meeting is the quorum. Most people find that kind of strange, but imagine an organization with thousands of members and only a couple hundred of them regularly show up. It could be impossible to get a quorum, and then the organization just could never act. So you need to look at the governing documents because a lot of them say something different, but if it doesn't say anything different, then whoever shows up at a duly convened meeting is a quorum. If you don't have members, the directors change the governing documents. And the default rule, the rule if the governing documents don't say otherwise, is you need a majority of the total number of directors to be a quorum to have a valid meeting. And at that valid meeting, a majority of the directors present can vote to change the documents. And I'll say one final time, read the governing documents because a lot of them set different standards, usually more restrictive standards than these. And before you go changing the governing documents, I ask, is your change necessary? That poster is from World War II. They used to ask people during World War II, is your trip necessary, to try to save fuel? Is your change necessary? Well, amendments to the Articles of Organization have to be filed with the Secretary of State. If they're not filed, they're not, they're not really valid, even if they were passed, if they're not filed. So you're in kind of a limbo situation that's awkward. Changes to the articles and code of regulations have to be disclosed on Form 990, which means you're giving IRS a chance to look at your changes. And if you're changing the purposes clause, they may not like your changes. You might no longer be a charity if you describe it incorrectly. Another thing is the Attorney General's office has authority. They don't usually exercise it, but they have authority to come in if you change your purposes clause and question the change in purpose and whether that change in purpose is allowed. So again, think twice, especially before you change the articles. And then the Code of Regulations, if it's a change to governance, that's probably fine, but if it's a change to purpose, that's pretty dangerous. So let's talk about the primary duties of directors. There are three primary duties. The duty of care, the duty of loyalty, and the duty of obedience. and these are fiduciary duties. Fiduciary means that you are responsible, you're legally responsible to a higher duty than just an ordinary person acting in an ordinary situation. I told you that directors in a nonprofit used to be called trustees. There are some similarities between directors and trustees because they're both fiduciary positions. You have a special higher duty than the ordinary person, even though directors and trustees are different. So what's the duty of care? First of all, show up. If there are meetings, show up. If there are monthly meetings and you're only going to make 2 or 3 per year, it'd be better not to be on the board because there's a lot going on. And if you're not there to vote and to keep an eye on what's going on, then you're not fulfilling your duty. Second, pay attention. Sometimes I've been to long meetings. They're not all exciting, but when the executive director makes presentations, when they present the financials, pay attention to what's going on, because if there's something shady going on and you're just not paying attention, you could be responsible for that. So stay informed. Read the materials in advance of the meeting. Read the materials they give you at the meeting. Ask questions. Maybe read the governing documents. If you haven't read your articles of incorporation or code of regulations, it might be a good idea to look at them. The common practice that everyone has been doing, hopefully it follows those governing documents, but sometimes people forget what is in them. Duty of care involves managing the resources of the organization wisely. By resources, I mean staff time, director time, money, assets, and reputation. And remember, since nobody owns a charity, directors have a fiduciary duty to care. You have a higher duty than just an ordinary person to care about that organization and pay attention. The duty of loyalty, you have a duty of loyalty to the organization. You don't have a duty of loyalty to the founders or to the staff or to third parties. Often a nonprofit will have a founder who's just the defining force of the organization, and people kind of think of the organization as belonging to the founder, and we need to protect the founder no matter what, and that's not true. It's extremely awkward, but occasionally an organization will need to rein in a founder or perhaps even terminate a founder, and that's awkward. But if push comes to shove, you need to be loyal to the organization. You can't be loyal to a person. Loyalty also gets involved in compensation questions. The duty of loyalty means you want to make sure that the organization is not paying excessive compensation to staff, contractors, others. Duty of loyalty means you promote the mission of the organization. Now, why does the organization exist? It's not to provide employment to the staff. There's a charitable mission. So make sure you're focused on the mission. Then finally, avoid self-dealing. So you should not enter into transactions where you're benefiting excessively. We'll talk a little bit more about what's permissible and what's not in a moment. And avoid or manage conflicts of interest. So that includes not just your own conflicts of interest, but others. If you find out that there is a questionable relationship with a staff member or a director, you have a duty to look into that and possibly vote on that and possibly end it if it's not appropriate. Duty of obedience. So first, follow applicable laws and regulations. Even if you're doing everything else correctly, if you're violating the law, the organization will be in trouble, and you need to make sure that doesn't happen. Stick to the mission. Some of these duties, some of the things you need to do involve multiple duties. So stick to the mission. That could involve multiple duties. Comply with your organizational documents. Follow grant requirements. Usually a grant agreement has restrictions on what you can and can't do with the money. Follow fund restrictions. If you get gifts that are designated for certain purposes, you need to make sure those are accounted for properly and you spend the money in the right way. And only in compliance with the restrictions on the gift, and then comply with the corporation policies. I guess if you don't want the corporation to comply with the policy, you can change the policy. But to the extent you have a policy, you should follow it. Ohio law addresses the duty of directors. Now, keep in mind that the Ohio nonprofit law is not just for charities. It also involves a lot of other types of nonprofits like social clubs and chambers of commerce and such. So the Ohio law standards tend to be a lot lower than the best practices for charities. So Ohio law, the duties of directors, if you look at this is pretty lenient. Directors have to act in good faith. They have to act in a manner reasonably believed to be in the best interest of the corporation or not opposed to the best interests of the corporation. So that implies you can benefit yourself as long as you're not cheating the corporation. And you have to exercise the care of an ordinarily prudent person in a like position under similar circumstances. Boy, that is just packed with potential holes that you can use to save yourself. So an ordinarily, basically what would a reasonable person do in that situation? So that's a pretty relative standard. Again, this is not stating the best standard, the best practice. This is just the minimum standard you need to meet in order not to violate the Ohio Nonprofit Corporation Act. And then finally, the Ohio law says that you can rely on the reports and opinions of employees, experts, and committees. The list is a lot longer than that, but the idea is if you have employees, experts, others give an opinion to the board, you don't have to question all of that information. I guess if it looks questionable, you should ask. But you can, to some extent, you can rely on what other people tell you to make your decision. So if someone gave you bogus information and it looked right, and you made a bad decision based on that bogus information, you're not necessarily going to be liable. When is a director liable? That citation is to the Ohio statute. The general rule is for a director to be liable for an action or omission, failure to act, there has to be clear and convincing evidence that the director deliberately intended to injure the corporation or had reckless disregard for the best interest of the corporation. Again, this is a really low standard. Reckless disregard, that's not just negligence, that's just blithely, hey, I don't care if this hurts the corporation, I'm doing it anyway. I'm not trying to hurt the corporation, but I really don't care whether it does or not. Deliberate intent is even harder to prove. And then clear and convincing evidence, what does that mean? There's not an exact definition, but when I was in law school, the kind of the rule of thumb was beyond a reasonable doubt in a criminal case was sort of like 95% sure. Clear and convincing was sort of 75% sure. And then the other standard, more likely than not, is 51% sure. So 75% sure that you were being deliberately wrong or just completely reckless, that's pretty hard to prove. Again, this is the minimum standard. This is not what you should strive for. This is just where you're legally liable under Ohio law. A director can also be liable for voting. Basically, if you vote for a distribution that's contrary to the law or the articles, if you vote for an improper payment and liquidation, or if you're voting for loans to officers, directors, or members, then and it goes bad, then the director can be liable for that amount. So just as an example, if the articles say that if you terminate the organization and there's leftover money, first you pay your debts and then you can pay it over to another charity of this particular type, and the board says, you know what, we're going to distribute the proceeds to the directors or let's say they distribute to the membership, and you're director, you're not a member, so that the proceeds go to the members, and the members are not charities. that the directors can be legally responsible for that distribution that they made. And if a question comes up and you're not allowed to vote for it, you have to vote no. Or if you don't vote no, you have to dissent in writing. So a piece of paper or an email saying, "Hey, I'm against this matter. I'm dissenting. You can't do this with my consent. I am objecting to this." If you're silent, then silence implies consent here, and you could be liable. Let's talk about conflicts of interest for a minute. Those often come up in nonprofits. The Form 990, I gave you a little excerpt there. They ask, it asks if you have a written conflict of interest policy. You can check yes or no. There's not a specific penalty if you check no, but let me tell you, the best answer is yes. When IRS asks if you have a conflict of interest policy, you don't want to say no, we don't care about that. You want to say, oh, yes, of course we do. The next question is, look at 12B, is there an annual certification? Do you require officers, directors, trustees, key employees to do an annual certification? The best answer there is yes as well. IRS has a sample safe harbor policy that's frankly really poorly written. I typically use that as a starting point, but I have my own conflict of interest policies. You're allowed to do a customized policy, and often the IRS policy doesn't address a particular organization very well. Say, for example, that you work closely with another organization, or if there's an organization that's affiliated with government, you need to tweak that. But the last point is what you need to remember. It's if you have a somewhat weak policy and you follow it, you're better off than if you have a very strict policy and you violate it. Just to have a strict policy and violate it is to just set yourself up for a claim. So, if you can live with a strong policy, great, do it. But don't try to set up a policy that's the strictest you can think of if you can't follow it later on. So, how does Ohio law treat conflicts? Again, there's a very loose minimum standard. It's okay if the material facts are disclosed to the board and approved by the board and they're acting reasonably in good faith. You don't need that acting reasonably in good faith if it's disclosed and approved by the members, or if it's fair to the corporation at the time it was approved. This is a really loose standard. The code of regulations of your organization might be stricter, and IRS looks at a little more strictly as well. So how does IRS treat conflicts? Private benefit is okay if it is insubstantial and incidental. Where it says or there, change the or to an and. It has to be small, and it has to be incidental. Means it's not the purpose of the arrangement. Insubstantial means it's quite small. So private benefit can be okay. Private inurement is completely wrong. There's not a really clear line between private benefit and private inurement, but if IRS says I see private inurement, they're telling you you've got a big problem. So there are also rules on self-dealing. They only affect private foundations, and those are prohibited transactions. So for self-dealing, you don't even look at whether it's fair to the organization. You don't do a private benefit analysis. It's just flat wrong. IRS can impose sanctions on organizations. Traditionally, the only thing they could do is revoke the exempt status of the organization. But now, for I don't know, probably the past 15 years or so, they also have intermediate sanctions, which are fines. They can fine the organization. They can fine the individuals involved. So the directors, employees, others, anybody who deals with an exempt organization can be fined if they violate, if they create private inurement. So how do you protect officers and directors? Ohio law says that you may indemnify directors, officers, employees, agents, and volunteers. The Code of Regulations usually has language on that, but I question, is it may indemnify or shall indemnify? Sometimes it says you shall indemnify all of those people. And I just then ask the question, do you want to require the corporation to indemnify employees and volunteers? Do you want to be responsible for their behavior? Some cases you might, some cases you might not, but this is not a one-size-fits-all approach. Every situation is different. Finally, director and officer insurance. If you're a director or an officer of an organization, you should really make sure there's insurance to cover you if something goes wrong. It's usually not very expensive, and it covers defense costs as well as damages. So even if you're sued without justification, it can help protect you. We'll talk a bit about funding. Charitable contributions, you give a written acknowledgement. That's required. Most organizations are familiar with that. If you're soliciting from people other than your members, you often need to get a charitable solicitation permit from the Ohio Attorney General. Quid pro quo, that means to get something back for something else. If you're doing if there's a bargain sale, or if somebody makes a donation and they get something back in return, you need counsel because that needs to be disclosed properly, and you need to make sure that's a proper transaction. From the position of the donor, it can be a charitable contribution or an advertising expense. So if you get a contribution, you send an acknowledgement, but the donor might call that an advertising expense, and that can be proper even if you call it a donation. It depends on the donor's perspective. There's special rules for donated items. If you drive into Michigan, there are all those billboards saying donate your boat and get a charitable donation. There are some pitfalls there. The chief one being if somebody donates an item to you, they claim a big tax deduction and you sell it within, I think it's 2 years, for a lesser amount, then that reduces their charitable contribution that they're not going to be happy with. So that's an area where you need help as well. Finally, membership fees. Membership fees may or may not be a charitable contribution depending on what you get back in return. For the Toledo Zoo, for example, if you sign up for a membership, they'll give you, depending on which membership you sign up for, they'll send you a letter saying this much was a deduction. And so if you get a $50 membership, perhaps $30 is a deduction. So that there's a calculus that goes in there determining the value of what members get back. So not all of it is a charitable contribution. Public or private grants, there are grant agreements. They typically have strings attached. Just follow, if you get a grant, make sure that you are, make sure it aligns with the mission, you follow the rules. And a lot of charities think of grants as this magic pot of gold where if they need money, well, we'll just get grants. If you work in the area of grants, it's not as simple as that. There's not a magic pot of gold that you can just pull money out whenever you want it. A program revenue, if it's revenue from a program related to your exempt function, there are different types there, but you're generally subject to the same types of laws as for-profit businesses. In the nonprofit world, there's not a lot of restrictions on program revenue. But games of chance are a highly regulated area. There are some guidelines there, but just if you want to do a game of chance, get help from counsel, because especially if you have an event where there's alcohol. There were several cases recently where people were, the organizers were let out in handcuffs. They were volunteers. They were let out in handcuffs. And who turned them in? It was another charity that had a casino night that did comply, and they turned in the one that wasn't complying. So be careful. For tax issues, we won't have time to go through this, but here's a list of all the taxes that charities generally pay and don't pay. In some cases, it's rather complicated. I tried to highlight those. Unrelated trade or business, if you have income that's not related to your exempt function, you basically need to pay tax on that. Muller's Spaghetti was a famous case on that area. If there are questions on UBTI, we can cover those in the question and answer period. Political activity is highly regulated. Advocating a particular candidate is prohibited to charities. So do not say we endorse, John Doe for president or vice president or any candidacy. A nonprofit can do issue advocacy related to the mission if it's not substantial in time or money. So what's substantial, that's kind of a rule of reason approach. If you're going to do significant political activity, there's a safe harbor test that requires you to calculate the time and money spent on political activity. So again, get help if that's an issue for you. Employment issues. Most employment laws apply equally to nonprofits as they do to for-profits. I highlighted employment taxes and withholding because if you don't pay employment taxes and withholding, officers and directors can be personally liable. You do not want to be personally liable for a volunteer position. So make sure that someone is paying attention to that. We talked about the risks of mischaracterizing employees and independent contractors. And then finally, if you have volunteers, treat volunteers as unpaid employees in the sense that you want to screen them. You might want to interview them. These people are representing your organization, and if they do bad things, your organization can be responsible. So don't take volunteers that you would not hire as employees. And then finally, intellectual property issues. Nonprofits often have intellectual property. You may not think you do, but your name and your logo are trademarks. You probably have copyrights on forms, flyers, definitely your website. You may have software that you use. You have trade secrets, your donor lists, your member lists, well, member lists maybe, internal forms, your plans. Those are things you want to keep as trade secrets. So you do have an intellectual property. You do need to protect it. If you have employees who are doing creative things, you may want assignment of invention, assignment of copyright agreements. And then finally, in red, check your website. I've seen lots of nonprofits and for-profits who pull pictures off the internet and put them on their website. That could be a copyright violation. Check the website, or you can have someone check your website. I often do this for clients to just kind of troubleshoot and look for issues. Because nonprofits are liable for intellectual property infringement just the same as anybody else. So we've reached the end of the program. If you have questions, please send them in, and I'll be happy to take a shot at answering them.
We do have some. This is Heather from the center. And again, if you want to add a question to the list here, we'll try and get through as many as we can. If we don't get to some, we will answer them and send them out with the link. You can go to the Q&A, the question and answer box here in the Zoom webinar platform. Okay, so Craig, these are all over the map here. So,
all right.
We have governing documents, but none of us were on the board when they were created. Should they be reviewed, and who could we get to review the documents?
If you have ancient scrolls for your governing documents, it would be a good idea to take a look at, to have someone take a look at them. Your articles of incorporation, if you have trouble finding those have to be filed with the Secretary of State. So, an attorney can pull those from the Secretary of State and definitively know what those are. The Code of Regulations is sometimes different. Some those aren't filed anywhere, and sometimes organizations don't have a clean copy, or they're not sure what the amendments made. So that could be more about an open question. But yeah, an attorney who works a lot with nonprofits can look at those, and often if you're still, and the board should look at those as well in terms of process. Do they still describe how you conduct business? And if they don't, do you want to change your process, or do you want to change the documents? For example, if it says you're meeting monthly and you meet quarterly or less often, it might be a good idea to change the Code of Regulations to say that you only need to meet quarterly. So you don't want to set standards that you're not meeting. That can be an area. I mean, lawsuits are started over that.
Okay. The next question. What do you recommend if the board doesn't want to deal with a conflict of interest? Now, it doesn't say whether this is a board member or a staff member asking, but what do you recommend?
Well, the conflict of interest policy usually describes a process for dealing with conflicts of interest. And it usually goes that the person who has the conflict has a duty to bring it up to the board, and then the board considers it. There can be multiple layers. There are different ways of dealing with it, but the classic one is the person with the conflict discloses it. The board decides whether it's a problem or not. And the board might decide it's not a problem. If the board might decide, well, okay, it's a conflict, but it benefits the organization, it meets the standards, so we're going to allow it. Or the board could say, we're not going to, no, we can't approve this, so you're not allowed to do it. The board can't just say we're going to ignore it. So it needs to be addressed. It doesn't, it could be approved, it could be denied, but it needs to be addressed. If the board doesn't address it, then the board isn't fulfilling its duties. Probably at least two, well, maybe all three duties: care, obedience, and loyalty.
And I think you mentioned that it's also about documentation. So if they address it, I'm assuming you want that recorded in the minutes of that meeting.
Yeah, typically you have good meeting minutes, or you can have the secretary can sign can create the minutes, or you can do an action by written consent where the board approves or records the decision it made and why. If you're going to approve something that's questionable, you can document why, and perhaps you have reports you're relying on. Perhaps you had another employee who's not part of the conflict give you testimony. So you want to establish what you relied on in making the decision. And going back to Ohio law, if you document your decision and the reasons why, and you acted in good faith and reasonably, if it turns out you're wrong, you're probably still okay. Usually IRS is not extremely keen to go after people who are just in the wrong place, who made a bad decision but did it in the right way. You just don't want to be asleep at the switch.
And if you haven't discovered it yet, there is a board governance and best practices checklist that's available at no cost on our website at C4MPR, as well as sample conflict of interest policies. I mean, there's a number of resources, and if you can't find what you need, you can give us a call or reach out by email. Okay, so you covered a lot of ground in this webinar. What are some of the most common problems officers need to deal with?
I'd say conflicts are kind of the classic situation, whereas a situation comes up and we want to, we have an insurance agent on the board and we need to buy insurance, and should we buy it from that agency? If you're a private foundation, you cannot. It is flatly prohibited, and there are specific penalties. If you're a charity, you need to look into the situation a bit more. If it's market price, if you're thinking, if the board decides we're not going to get a better deal anywhere else, and this person's on the boards, so they'll make sure the relationship is good, perhaps that's okay. If you need to open a bank account and you have a banker on the board and you go to that person's bank, again, look at the alternatives. And if you can say, look, we checked with 5 banks, and this was as good a deal as we could get anywhere, perhaps better than we could get anywhere, so we chose this bank, that's okay. If it turns out that bank is charging you 3 times the fee of other banks, then it becomes a little harder to justify. So do the due diligence. As I said, record what you relied on and make a prudent decision. But yeah, conflicts are kind of the classic situation that come up. You may find issues with employees. Employee compensation can be problematic too. It's often depending on the budget, sometimes you can't always do this, but if you have the budget and if it's an important position, it'd be a good idea to get a salary survey. There are organizations in town where you can get salary surveys, or there's information you can find on the internet. You don't have to pay at the median or below the median, but you need to justify the salary you pay to your employees and make sure you're not overpaying them unfairly.
Mm-hmm. Also, if you're not aware, the Center partners with OANO every other year for a salary and benefit survey in the nonprofit sector, and it does isolate the Northwest Ohio data, so you can get a feel specific to our area, and you can learn more about that on our website. If you participate, you get a free copy. Another question, what types of issues should be addressed by executive committee versus full board? What is the executive committee's responsibility for informing the full board?
And what types of issues? There's probably a culture that you can establish. I mean, certainly the Code of Regulations can give guidance on what issues go to the executive committee versus the full board. And those are typically sort of items that require a decision that the staff shouldn't be making on their own, but not fundamental decisions. Do we change the Code of Regulations? Maybe the executive committee would recommend it, of course, to the board, but that's something that needs to be approved by the full board. If there's an employee who's underperforming who needs to be terminated right away, that may be something that the executive committee would weigh in on, and then later go to the full board and get ratification. But it's sort of a when you see it situation. If it's something that's really big and fundamental, if you're uncertain about it, have the full board make the decision. Except if it's an emergency and you really can't wait, have the executive committee do it and then report to the board. The last bit, what should the executive committee report to the board? Everything the executive committee does should report to the board. The executive committee is subordinate to the board, so the board can undo executive committee actions. If the executive committee approves a contract, it gets signed and the board undoes it. The contract is still valid. The organization could be liable, but the board does have the ability to back out of that contract.
What is private inurement?
Private inurement is a bad thing. We talked about private benefit and private inurement, and it's kind of a conclusory definition. If it's private inurement, it's against the law. But an example of private inurement would be if a staff member is diverting money from the organization to the staff member's personal account, embezzlement, that's certainly private inurement. And the staff member could be, it's illegal for many other reasons, but IRS could fine the staff member in addition to everything else that goes on for private inurement. If the board was completely not paying attention, the board could be liable for that as well. Selling assets to the organization at an inflated price, buying assets at a reduced price, all of those sorts of things can be private inurement, but you need to do a public benefit analysis, and private inurement is kind of a guilty verdict. And the private benefit is the question you ask, and if the conclusion is it's private inurement, that's kind of the guilty verdict.
Right. So that's a nice, I don't know if it's a nice segue, but it's a segue into the next question. We have seen some local cases where staff got into legal trouble, including criminal charges. What is a board to do?
Boy, I've had to deal with that a few times. Sometimes the board doesn't want to file criminal charges because then it becomes public and it's embarrassing to the organization and it might scare off donors. If it's, if there's real embezzlement, maybe if it was $20, you'd fire the employee and not do anything. But if it's a significant amount, it's really something that needs to be disclosed. I think the board has a fiduciary duty, if it's significant, to report that to the police. The police may or may not want to file criminal charges, but it needs to be disclosed. It may be even something you want to disclose to the Internal Revenue Service. So the Internal Revenue Service would impose sanctions on that person, but would come to the board and say, okay, the board, you did right, you found it, you reported it, so you're not liable, but the person who took the money, they're liable. If the board engaged in a cover-up, didn't file criminal charges, didn't report anything, just sort of cover the whole thing up to protect the reputation, then the board could be liable for sanctions, and that's not a good thing.
Just a reminder, if you have a question, just type it into the Q&A box in the platform. We have a couple more. Who investigates a 501c3 organization if someone reports a problem?
I would say, well, who is it reported to? If an employee goes to the executive director, the executive director probably does an internal review, and if the executive director thinks there's something there, reports it up to the board. If you report it to the board does a review, and might report it. I mean, if if a whistleblower goes to IRS might start an audit. If the whistleblower goes to the Ohio AG might start an audit. So it depends on who's it's reported to, and there are a lot of different methods for investigating it. It depends on the type of claim, to whom it's reported, how big it is, that sort of thing. I
would assume if you get a knock or a call from the AG's office, that's not going to be a pleasant experience.
Yeah, if you get a non-routine letter from Internal Revenue Service or the AG's office, then you want legal help. You don't want to, there's potential liability, and you want to handle the communication, the internal investigation in a very prudent way to limit the damage to the perpetrators and protect the board from being accused of not doing its duty.
I'm going to assume at best it's an interruption of normal day-to-day activities.
Yes.
This investigation is going to start, and you're going to have to jump when they say jump.
Yes, and this is another. I mean, this can be a whole topic on its own. But if there's any question of wrongdoing, do not delete anything. And if it's employee emails or that sort of thing, lock them down. You don't want to destroy or allow someone else to destroy records that could be evidence in a claim. You want to try to preserve everything. And if you've done nothing wrong, that can help save you. You might find an email from long ago that helps prove that you had nothing to do with it, and preserve the emails that show who was involved. Emails, text records, voicemails, all of that stuff. If there's any question, don't delete anything.
I think this is our final question. Where can we start to research director and officer insurance?
There are a number of insurance companies in town that offer director and officer insurance. Can I mention a name?
Actually, why don't you send them to me?
Okay.
So the center does maintain a list of consultants on a variety of topics. Mm-hmm. And usually it is recommended by someone. These are experts in the field. And we do have at least one that I'm aware of who specializes in the area of nonprofits. But yes, please send the contact information to me. If you want to ask for information or can't find anything, the center has an online technical assistance form you can fill out. I promise you it will only take 3 minutes or less to complete. And we try to get back to those within 24 hours, at least acknowledging that we've received it and that we're working on something. So thank you. I think those are all the questions that we have for today.
Okay. This is Maggie Humphrey from the Bar Association again. I just wanted to make a quick plug for a program that we started in collaboration with the center. We're calling it Nonprofit Connect, and it's really just an opportunity for our pro bono attorneys to provide legal assistance to nonprofits who can't afford an attorney. So if your organization is facing a legal issue that you think you need some help with and you can't afford to hire an attorney, please feel free to reach out to the Bar Association. You can go to our website to learn a little bit more about that. So thank you for participating in today's webinar. A special thank you to Craig for sharing his time and experience with all of you. As a reminder, a copy of the slides will be sent to you after the webinar. The last slide includes resources available through the center related to this topic. This webinar is being recorded, and a replay link will be emailed to you within 24 to 48 hours. You will also receive a link to a very short survey to provide feedback about this experience. To learn more about other opportunities such as this one, visit c4npr.org. We hope to connect with you soon.